very much. I'm very honored to be here and to talk with you about the conscience of the Constitution and about the Pacific Legal Foundation and some of the work that we do. I brought here a brochure about the foundation in case you are not already familiar with us, and you can pick up that over there and fill out a little card to get some more information about our work. Pacific Legal Foundation was founded in the 1970s in an effort to counterbalance some of the work that was being done on the left by groups like the ACLU, the NAACP Legal Defense Fund, and other organizations that were trying to challenge the constitutionality of Governor Reagan's welfare reform programs. And Reagan said, well, why aren't there any legal groups on the conservative or the libertarian side that would fight for constitutional rights and individual freedom? And three of his subordinates said, hey, that's not a bad idea. And so they founded PLF in 1973, and we've been suing the bureaucrats ever since. Which, by the way, is the best job in the world. I would do it for free if I had to. In fact, we do it for free. We do not charge our clients for our legal representation when we defend them in courts across the country in defense of private property rights, economic liberty, racial equality, and other important constitutional issues. But I think the central theme of all that we do is very well summed up by James Madison in an essay that he wrote in the 1790s. He said, in Europe, charters of liberty have been granted by power. America has set the example of charters of power granted by liberty. This revolution in the practice of the world may, with an honest praise, be pronounced the most triumphant epoch of its history. What he meant by that was, in the past, bills of rights or charters of freedom had been given to the people by the king as a form of a privilege, like the Magna Carta or the English Bill of Rights or the English Petition of Right. These had been promises by the king to respect the subject. They were handed down from a superior to an inferior. He said, the king would say, all right, I will give you these rights. And in America, the reverse had happened. The people had gotten together and hired a government and written a constitution that said, you may go this far and no further, because we have rights to begin with. We don't need permissions from the government needs permissions from us. That was the fundamental discovery, the fundamental innovation of the Founding Fathers in the Declaration of Independence, when they said, all men are created equal, they're endowed with fundamental rights, no just government may deprive them of these rights. They create government to secure these rights. Right? Governments are instituted to secure these rights, and they derive their just powers from the consent of the governed. Whenever any government becomes destructive of these ends, it is the right of the people to alter or to abolish it and to institute new government, laying its foundation on such principles and organizing its powers in such form as to them shall seem most likely to affect their safety and happiness. So the government exists at the people's will and not the reverse. Now, this was a major reversal of the principles of the English common law that had preceded it. At the English common law from, say, the 17th century, there was a principle that we now call prior restraint. Prior restraint is a term lawyers usually use it in the context of freedom of speech, right? But what it means is, under the rule of prior restraint, you're not allowed to do the thing. You're not allowed to publish the book or say the phrase until you get government's permission. Under the First Amendment, that is unconstitutional. The First Amendment prohibits the government from imposing a prior restraint on you. You can be punished after you speak if you engage in libel and slander or fraud or something like that, but you can't be restrained from speaking in the first place. The idea of prior restraint was just the way things were, mostly under the English common law. In England, before the American Revolution, you couldn't start a church without government permission. You couldn't publish a book without government permission. You couldn't form a corporation without government permission. You couldn't leave England without government permission, right? And beginning in the 17th century, in about the 1620s or so, this was really being challenged by the great precursors of the American Revolution. People like John Milton, my favorite Christian libertarian, who wrote the book Areopagitica, still the world's most beautiful defense of freedom of press, right? In which he said, why should I have to get a license to publish a book? Actually, it's kind of a funny story. Milton, anybody here read Paradise Lost? Anybody in here enjoy Paradise Lost? I love it. I love John Milton. I love Paradise Lost, but I think it was Samuel Johnson said, no man ever wished it longer, right? Anyway, Milton was a very serious, very scholarly guy, and he was in his 40s or so. He married a teenage girl, which was the way things were back then, and she stuck around for a few weeks, and she said, I don't much like it here. Mr. Milton is very puritanical. He wasn't a Puritan, but he was very puritanical. So she ran home to be with her parents instead. And so Milton very characteristically responded to his wife's abandoning him by writing a book called The Doctrine and Discipline of Divorce, arguing that divorce should be legal, which is really something in 17th century England, right, to write a book like that. So when this book was published, it was very scandalous, and people in Parliament started to investigate him and said, wait a minute, when did he get permission to write this book? And when he found out about that, he got outraged and, again, responded very characteristically by writing another book, Areopagitica, which defends freedom of press. And this idea of prior restraint was challenged also by the great Whig philosopher John Locke, who is really the intellectual godfather of the American Revolution. Locke said, freedom is not, as we are told, a liberty for every man to do as he lists, for who could be free when every other man's humor might domineer over him? But a liberty to dispose and order as he lists his person, actions, possessions, and his whole property within the allowance of those laws under which he is, and therein not to be subject to the arbitrary will of another, but to freely follow his own. Freedom means not having to ask permission. That's what freedom is, right? When I was recently speaking to some high school students, and when I talk to high school students, they get this idea real quick. They get the difference between permissions and freedoms real fast, because they don't have any freedom. They only have permissions, right? I mean, I'm 30. Well, I'll be 38 years old tomorrow, and I still love the feeling of being a grown-up. God, I can drive somewhere just because I want to, and I don't have to ask anybody else's permission. I love that feeling. I tell people sometimes, I love my freedom. I carry it with me in my pocket. I carry my freedom with me wrapped up in cellophane. It gets smaller all the time, so I try to keep it airtight, but somehow it keeps slipping away from me. Every now and then I'll take out my freedom and I'll just look at it a little bit, play with it, and think about, this is my freedom. I just love my freedom. And anyway, so what the Founding Fathers did was they replaced this model of privileges with the idea of freedom or rights. A great example of how they did this is religious freedom. Under the British Constitution, at the time of the Revolution, the people of Great Britain enjoyed a great deal of what we might call religious freedom. They didn't call it religious freedom. They called it religious toleration. And the great British legal law professor William Blackstone, very famous author of treatises on the meaning of the British Constitution, William Blackstone was very proud of the toleration allowed to religious groups under the British Constitution. Why, we even allow Catholics to own property, right? Very liberal regime at that time. But that wasn't enough for the American revolutionaries. Thomas Paine said, toleration is not the opposite of intoleration, but the counterfeit of it. Both are despotisms. The one assumes to itself the right of withholding liberty of conscience, and the other of granting it. The one is the Pope armed with a fire and stake, and the other is the Pope selling or granting indulgences. The government has no more right to deprive you of religious freedom, and no more right to grant you religious freedom. Your freedom belongs to you. The question is whether the government has the right to take it away, right? And so Thomas Jefferson wrote the Virginia Statute of Religious Freedom in the 1770s. He actually, after finishing the Declaration, he returned to Virginia to write a new code of laws for Virginia. And one of these laws was the Statute of Virginia for Religious Freedom. One of the three things he was proudest of. One of the three things he put on his tombstone. He didn't put his presidency on there. He didn't put the Louisiana Purchase on there. But he put the Virginia Statute for Religious Freedom on his gravestone. And the great innovation of the Virginia Statute was the idea of religious liberty instead of religious toleration. Jefferson said, our rulers can have authority only over such natural rights as we have submitted to them. The rights of conscience we never submitted. We could not submit. We are answerable for them to our God. The legitimate powers of government extend only to such acts as are injurious to others. But it does me no injury for my neighbor to say that there are 20 gods or no God. It neither picks my pocket nor breaks my leg. Right? So Jefferson's idea of liberty is government exists to protect people from having their pockets picked or their legs broken. It doesn't exist to go around and make sure that everybody's living right. Right? This idea of replacing the presumption against freedom with the presumption of freedom was the great innovation of the American Revolution. Who has to ask permission? When we talk about freedom versus asking permission, who has to ask permission? Children? People who are like children? Slaves? Employees? Until very recently, women, right? Women had to ask permission for basically everything in life. Right? There's a great example of this in the case of Muller versus Oregon in the 1900s. There's a Supreme Court decision. What happened in Muller was, I must hasten to say, I'm not making this up. What happened in the Muller case was the Supreme Court upheld a law that imposed a minimum wage for women. The idea was women are too stupid to negotiate for wages with employers. They're too shy, retiring little violets who can't possibly be expected to actually say to an employer, I want a raise. That's too much for them. So government has to come in and protect them against the low wages by passing a minimum wage law to protect them, right? And that's what the Supreme Court said. Right? In 1923, there was a case called Adkins versus Children's Hospital that threw that decision out, overruled the Muller decisions. It's a case by one of my favorite Supreme Court justices, George Sutherland. And what happened in the Adkins case was that Washington, D.C. passed a minimum wage law for women. Now, what's going to happen if a minimum wage law is passed that only applies to women? What's that? A form of discrimination. What's going to happen to the women? They're going to lose their jobs, right? If you make it more expensive to hire the women, the employers are going to fire them and hire men instead, right? Which is why the male-dominated trade unions supported minimum wage laws for women, because it is a way of excluding competition for jobs, right? So Washington, D.C. passes this law, and a woman named Willie Lyons, she's an elevator operator at a hospital in Washington, D.C., she loses her job. She liked her job. She was happy with her job. But it didn't make as much as the law required. This is the great mystery of minimum wage laws, by the way. Why is it that you're better off unemployed at $12 an hour than employed at $9 an hour, right? This is the classic way that liberals think, right? Liberals think that, well, I'm going to make it harder and more expensive for people to hire you and give you a job, and then I'm going to pat myself on my back for my compassion, right? Anyway, so she lost her job and she filed a lawsuit. And she said, this law violates the 14th Amendment to the Constitution of the United States. Now, I'm sure you all have your constitutions with you, so if you take those out. It's always a dangerous joke to play in an audience like this because you probably all have your constitutions. I always use my handy Constitution iPhone app. Very handy to carry around with you. It was updated the other day, and I still don't know why. Probably put Obamacare in there or something. Anyway, so she said the 14th Amendment says that the government cannot deprive me of liberty without due process of law. And that means the government can't just arbitrarily take my freedom away just because it wants to. And I have the right to make a contract if I want to, and there's no good reason to deprive me of that liberty. It doesn't protect anybody. You're just arbitrarily interfering with my freedom of choice. And the Supreme Court agreed and struck the law down. Now, Muller was 1905 and Adkins was 1923. Can you think of why the Supreme Court reversed course between those 2 years? Women have the right to vote. The Supreme Court cited the 19th Amendment as the basis for its decision. It said, okay, let's just assume that it was true in 1905 in the Muller case. Let's just assume that women really were too dumb that they couldn't defend themselves. Well, now we have the 19th Amendment. They're now equal citizens with us. They have the right to make their own decisions. It ain't nobody else's business if they do. And therefore, they have the right to make contracts of their own for employment if they want to. And that was the basis for the Supreme Court's decision. Women didn't have to ask permission anymore. They were therefore entitled to freedom. Of course, as you know, today, you basically need to get government permission for practically everything, right? You need government permission to own a gun, to build a house, to get a job. Something like 30% of all people in the workplace today need government permission in order to do their job. Right? You need government permission to drive a car. In many cases, you need government permission to speak. Right? We have these free speech zones where the government builds a cage, and you're allowed to speak inside the cage, but you're not allowed to speak outside of the cage. Right? That's a free speech zone. As some famous person recently said, I thought the entire United States is a free speech zone. What happened? How is it that we went from one state to another? The answer is the progressive era. The progressive intellectuals, beginning in about the 1880s, and really continuing to the present day, the progressive intellectuals were a group of people who had radical new ideas for how the Constitution ought to work. Basically, they had four great ideas. They were modernists. Like Homer Simpson says, who's to say what's right and wrong, what with our modern ways, right? They had these modern ideas for how the world ought to operate. All that stuff in the Declaration of Independence about individual rights is just nonsense. We now know that rights are given to you by the government, right? The number one, the first of the four progressive ideas was rights are just permissions that are given to you by the government for the government's own purposes. So, for example, freedom of speech. Founding fathers thought that freedom of speech was your right, because you own yourself, you own your opinions, you have the right to speak, and it ain't nobody else's business if you do. No. The progressives said, no, the reason we have free speech is because we want to have a debate. And so we allow people freedom of speech. You give it to them as a permission. And if we want to take it away from them, then we can do that too, right? So there was my least favorite Supreme Court Justice, Oliver Wendell Holmes, wrote an opinion in a case called Abrams versus United States, which is very famous for the phrase marketplace of ideas. You've probably heard that term. But and law students are taught that this was the basis of modern free speech jurisprudence. In fact, there's a brand new book out saying that Holmes's opinion in the Abrams case was the beginning of free speech in modern America. Right? One of the first lines in that opinion is, "Persecution seems perfectly logical to me," end quote. But Holmes goes on to say, but we don't persecute people because it's good for society to have a debate. And so we allow people to debate things, and then we can take that freedom away later if we want to, right? And that was the kind of thinking, that freedom of speech is instrumental to serving the overall needs of society. Rights are permissions given to you by the government for the government's own purposes. The second great progressive idea was that government exists to make society nice. Right? The Founding Fathers didn't think so. The Declaration says government exists to secure your rights, nothing more. Jefferson said a good government is one which shall restrain men from injuring one another, shall leave them otherwise free to regulate their own pursuits of industry and improvement, and shall not take from the mouth of labor the bread it has earned. But no, we modern progressives, we realize government exists to make society pleasant to live in. And so the progressives came up with wonderful new ideas for how to make society nice, like eugenics, segregation, zoning. What was the original purpose of zoning? Keep racial minorities out of white neighborhoods, right? Of course, we never do that today, right? Eminent domain for redevelopment was a progressive idea. In fact, the term blight was first used to describe property during the progressive era. These ideas of radical new income tax, prohibition, these were all ideas from the progressive era of how to make society a nice place to live, right? The third great progressive idea was living constitutionalism. The Constitution doesn't mean today what it meant yesterday. It can mean a different thing the next day. It's not really worth the paper it's printed on because it means whatever we say it means. And the fourth great progressive idea was judicial restraint. The idea that if the government decides to violate your rights, the courts should not do anything about it. Now, I want to emphasize this point because, unfortunately, a lot of my conservative friends have adopted this nonsense idea of judicial restraint. Oh, we don't want to have activist judges. Well, one of these days I'm going to make a poster. It's going to say, great moments in judicial restraint, right? Korematsu versus United States, and the government decided to throw the Japanese into prison camps in World War II, and the court said, oh, we're not going to be activists. We're not going to, that's fine. Don't bother us, right? Plessy versus Ferguson. The state of Louisiana wants to segregate the rail cars. The court's going to say, oh, well, we're not going to be activists. We're going to sit back. Kelo versus New London, the infamous eminent domain case, right? The state of Connecticut says, we're going to steal a woman's home and give it to private developers so they can build luxury condominiums. And the court says, oh, well, no, we're not going to be activists. We're going to stand back and let the democratic process have its way. That's judicial restraint. The idea of judicial restraint is when your rights are violated by the government and you go to court to get protection from the Constitution, the court goes, oh, I don't care. That's judicial restraint. Those are the four progressive ideas. Rights are permissions, government exists to make society nice, the Constitution is a living document, and courts shouldn't be involved in a way that blocks the will of the people. We don't want courts to violate the will of the people. Right? Justice Holmes said, if my fellow Americans want to go to hell, I will help them. That's my job, end quote. Now, I've read Federalist 78. Federalist 78 explains what the role of the courts are, and the phrase go to hell is not to be found in there. No, instead, Federalist 78 says, the will of the people is not a law, the will of the people is the Constitution. The law is only the will of a legislature. And if the will of the legislature conflicts with the will of the people, then the will of the legislature has to fall. So when a court finds that a law is unconstitutional, it is enforcing the will of the people, which is the Constitution. Right? So those are the four great progressive ideas, and I've always thought it was ironic that these ideas are called progressive because they're retrogressive. They're a way of re-establishing the old English system of prior restraints, of government gives you permissions and calls them rights. Justice Louis Brandeis, a very famous progressive lawyer, said, property and other rights of the individual must be remolded from time to time to meet the changing needs of society, end quote. Don't you love that word, remolded? What a great euphemism for violated. No, the government wasn't violating your rights. It was remolding your rights to meet the needs of society. Here's a hint. If it can be remolded to meet the needs of society, it's not a right. It's a permission. The progressives, what they did, if you want to put it in one sentence, what the progressives managed to do was to substitute democracy for liberty as the central value of the Constitution. The first sentence of the Constitution proclaims unambiguously that liberty is a blessing. It says, you can all see it. It says right there, the blessings of liberty. It doesn't say democracy. In fact, the word democracy is not to be found anywhere in the Constitution of the United States. On the contrary, the Constitution goes on at all this length in order to limit and restrict democracy. Laws have to pass through one house, then they have to pass through another house. Some of them have to get 2/3 vote. The president can veto them. The courts can review them. All these restrictions on what the government does in order to protect liberty. That was the central value of the Constitution. Now, a way to put this in modern terms is the difference between the nuisance model and the permit model. Now, I'm a lawyer, so we lawyers approach these property issues basically in these two different ways, the nuisance model and the permit model. Under the old common law, there was a concept of nuisance. We still have this around and we still use it, but the idea of nuisance was, it's based on an old phrase that, of course, we have to say in Latin because we're lawyers, so say it in Latin and people think you're real smart. So I didn't take Latin. I took ancient Greek. Here's another hint. If you're going to go to law school, don't take Greek. I used to date a veterinarian, she was a vet student, and I could always read her homework because it's in Greek. I don't know any Latin, but anyway, the Latin is sic utere something or other. And what that means is you have the right to use your property however you wish so long as you don't harm anybody else. And if you do harm somebody else, they can sue you and get an injunction to stop you. That's the idea of nuisance. The idea of permit is you're not allowed to do anything until you get the government's permission. Those are the two options. And you see, they're just the old options of prior restraint or non-prior restraint. Now, there are some benefits to the permit system. The idea of the permit system is that it prevents people from hurting one another, in theory, right? That's really the only benefit. And even that doesn't really do very much good, because there's a big problem with the permit system, right? The permit system allows a group of bureaucrats to decide when to give you a permit. And they might have all sorts of reasons for whether to give you a permit or not that have nothing to do with whether society really wants it or whether you have a right to do the thing or what have you. Right? The permit system stifles innovation and entrepreneurship. Under the nuisance system, you can come up with creative new ideas. Maybe they don't work, maybe, whatever, but you can try them. Under the permit system, you can't really do that. You have to pitch your idea to a group of bureaucrats to get permission to do your thing. So, for example, I won a case in February in the state of Kentucky where if you want to run a moving company, you first have to get permission from all of the existing moving companies in the state. All right? This is a law called a Certificate of Public Convenience and Necessity law, and I'm sorry to say it's on the books in about half of the states. In these states, you can't start a moving company until you first get a permit. And to get a permit, you file an application. And when you file an application, the government notifies all of the other moving companies and allows them to object. And guess what? They often do. We found that in the 5 years prior to our filing the lawsuit, 114 objections had been filed against 19 applicants. Not a single one of the 114 objections cited any concern about public safety or the person being dishonest or anything like that. In fact, all 114 objections, which had all been filed by the same lawyer in Kentucky, all cited explicitly that the reason they opposed the person getting a license was because they didn't want competition. Right? Once an objection is filed, you then have to go to a group of bureaucrats at the Kentucky Transportation Cabinet Motor Carrier Services Division in a building that looks like a spaceship and prove to them that there's a public need for a new moving company. Actually, the term that the statute actually used was you have to prove that existing moving services are inadequate. So, how do you prove that existing moving services are inadequate? That's the right answer. Nobody knows. The law doesn't say. There's no definition of the term inadequate in either the statute or in any decided court opinion in Kentucky or anything like, no regulation, nothing. Nobody knows what this term means. In fact, the state's chief official responsible for this licensing law testified under oath, quote, "We have no standards, no objective standards for determining whether existing services are inadequate." Nevertheless, in every case in which an application was protested, it was denied, including the case of Michael Ball, who had been in the moving business for 35 years when he decided to get his own company, get his own license, and start his own business, and was rejected in a written opinion that said, "You're fully qualified, but you would compete against existing moving companies, therefore denied." Right? There was even another case in which a guy named Larry Coyne, he had gone to his hearing, and he had hired an expert witness economist to prove that there was a need for a new moving company. Still denied, right? We filed a lawsuit on behalf of Lexington entrepreneur Raleigh Bruner and his company Wildcat Moving. And Raleigh owned, I think he had at the time about a dozen trucks and about 40 employees when all of a sudden he discovered, he didn't know this licensing law was even there. And all of a sudden he got in trouble with the government for not getting permission from his own competition before starting his company. And I'm glad to say that we went to court, and in February the federal district court struck down this law as unconstitutional for depriving him arbitrarily of his right to earn a living without unreasonable government interference. Now that's very satisfying result, but that is the first federal court decision since the New Deal ever to strike down one of these laws as unconstitutional. So, thank you. It's common sense, right? Nevertheless, in the state of Nevada, for example, you're not allowed to start a new moving company unless you prove to the government that it would foster sound economic conditions. What are sound economic conditions? Yeah, that's the right answer. Nobody knows. What we are doing as a result of the progressive influence in our law, by replacing the nuisance model with the permit model, by allowing the government to decide when we can exercise our freedoms and not, we're replacing a free society with a permission society, a society where you have to ask permission for absolutely everything. Now, when I talk about the subject, a lot of the time, there's some skeptics in the audience, which I always love, who say, well, you know, okay, I'm on board with this idea of freedom, but you have to be responsible, right? And our permit system exists to keep you responsible. And that word responsible is always very interesting to me because there's really two ways you can use the word responsible. You can use it to mean don't hurt other people, which is the nuisance model, the freedom model, right? Or you can use it to mean do what I say. You have freedom, but you have the responsibility to do what I tell you to do, right? That's what is typically meant when somebody objects and says, but you have to be responsible. And in that sense, I reject the idea of responsibility. You have a responsibility to yourself and your family, and you have a responsibility to your fellow citizens not to hurt them. You don't owe them your life. You don't owe them your energies. You don't owe them to the ability to compete without you having the right to enter into the market. By the way, you'll hear a lot about this issue in the coming months because the Supreme Court heard arguments just yesterday in a very important case on this issue. In North Carolina, the dental industry is regulated by the dental board. The dental board is made up entirely of practicing dentists who are elected to the board by other practicing dentists. It's not like a public election. The legislature doesn't choose them. It's just people who are currently working as dentists are on this board, and they're charged with enforcing the dentist licensing laws. Well, they don't really much like teeth whitening. I'm sure you're familiar with teeth whitening. This is a process that you can do at home with an over-the-counter kit. Some of you who are laughing have probably done teeth whitening at home with little plastic strips, got some peroxide on, you put it on there, you pull it off, and you get little white teeth, right? Well, in North Carolina, that's competing against the dentists, so they didn't like it, so they sent out 40 cease and desist orders to people who were doing teeth whitening at the shopping, or at the mall, right? Sometimes you'll see that, or at a makeup counter or something like that. They said, you're practicing dentistry without a license. So the Federal Trade Commission filed a lawsuit against the North Carolina Dentists Board for violating the anti-monopoly laws. Now, what's interesting about that is that, of course, the government is really the only entity that actually can create monopolies, and yet it's usually exempt from the anti-monopoly laws, right? And so that's what the North Carolina board said. They said, well, we're immune from the antitrust laws. And the Fourth Circuit Court of Appeals said no, they weren't. And that went up to the Supreme Court and was argued just yesterday. So if the Federal Trade Commission wins that case, it may open the door to entrepreneurs to have at least a weapon to defend themselves. I'm not a big fan of antitrust law. I think it's terrible. But at least it'll give entrepreneurs a tool to defend themselves against the abuse of licensing laws that often violates their right to earn a living, right? When you have to ask someone's permission for something, you are not a free person. To that extent, that other person has domain over you. The ultimate expression of that is slavery. A slave has to ask permission for absolutely everything. He doesn't own himself. Other people own him. Fortunately for us all, we do not live in a society like that today. We are very free, and we all ought to count our blessings for how free we really are. Sometimes, I do this for a living, and I know how depressing it can get. I just had a really bad thing happen to me at work today. I just had a client that I thought we were going to go and we were going to win this case. Client chickened out and backed out of the case, right? Very frustrating. Reminded me of George Washington at the Battle of White Plains when his militia turned and ran from the British and he threw his hat on the ground and he shouted, "Are these the men with whom I am to defend America?" Right? I get frustrated very much at my job. And I know how you can, when you feel that, you can get drawn into the idea of, my God, we are really on a bad road here. I was talking with this gentleman over here before we ate about this subject, and I want to make it clear to you, we are very free and very fortunate people. We have a court system that, for all of its real imperfections, nevertheless, still pays attention to the Constitution for the most part. I was there when the Obamacare case was decided. I know what you're all thinking, right? But for the most part, we still have a society that cares about our freedoms and our laws. And I really want to emphasize that word society, because the basic guarantee, the most fundamental protection of liberty that we have is not in the courts, it's not in the Congress, it's not in the vote, not in the ballot box. It's not, Frederick Douglass, my great hero Frederick Douglass used to say citizenship rested on the ballot box, the jury box, and the cartridge box, right? We still have these things for the most part. Things can be very bad, absolutely. But we still have the most important protection for our freedom, which is the minds and the hearts of the people who do care about freedom. American people are hungry and thirsty for leadership that will stand up and defend the ideas that our founding fathers left to us in the Declaration of Independence and in the Constitution. They're ready for it. They're eager for it. Yeah, right now things are kind of dry. Things, you know, the darkest hours just before dawn, all that sort of thing, you know. But when you compare our state to the state of affairs in, say, 1775, when the British had burned the city of Norfolk, Virginia to the ground, they were occupying Boston, occupying New York, occupying Philadelphia. They had blockaded the port of Boston, right? Imagine blockading the port of Boston. The British Parliament had passed a law declaring it had the power to bind the colonies, quote, in all cases whatsoever, end quote, right? That's pretty dark. That's pretty bad, right? The 1930s. In the 1930s, not only were Hitler and Stalin running free across Europe, but in the United States, the President of the United States had basically proclaimed himself the powers of dictatorship over the economy of the United States. The National Industrial Recovery Act made it illegal to choose your own chicken at the grocery store, right? We have lost a lot of this history, and it's a good thing because it's unpleasant to think about. The 1930s is the worst decade in the history of the race, right? The poet Auden called it a low, dishonest decade. We have things a lot better than they were then. Nevertheless, we have an obligation to ourselves and to our children to pass on the blessings of liberty unimpaired, and that can only be done by you. I mean, I go to court and I can argue these cases, and I love it, and it's a great thing to do, but really, it's society that matters. It's the opinion of the people. Tocqueville said, in Democracy in America, Tocqueville is very anxious about the United States Constitution. He says, the American people don't realize what they have in this Constitution, and that's a good thing. Tocqueville has the attitude toward the Constitution that I have when I think about the atomic bomb in 1945. My God, there were children playing with matches. That's what Tocqueville thought about the American Constitution. These people don't know how dangerous this weapon really is because it gives them so much freedom. He says if the American people really wanted to tyrannize over themselves, they could do a lot of real damage. He says, but there's a wonderful passage where he says, fortunately, there are things that the American people don't even have the imagination to dare. He says, the impious doctrine of tyranny, that whatever is good for society is morally just, has never been proclaimed in the United States, he says, because the spirit of the American people would not allow them to imagine it. Unfortunately, today, we are more and more imagining it. We're more and more imagining that, my God, we could use the government to do anything we want. We could use the government to stop people from drinking large sodas. Right? Smoking. I was talking to a law school yesterday, and I said, you know, I said, if you're a law student, you often get these emails from your relatives of silly laws across the country, like it's illegal in Colorado Springs to walk down the street with an ice cream cone in your pocket or something like that. Usually these things are fake, but it actually is illegal in this country to take a plant, take off its leaves, chop it up, set them on fire, and inhale the fumes. It's actually illegal in this country to do that. That is insane. Right? Kipling, the English writer Kipling said, all we have of freedom, all we use or know, this our fathers bought for us long and long ago. Ancient right, unnoticed as the breath we draw, leave to live by no man's leave underneath the law. Thank you very much. I'd be happy to answer any questions that you might have.
Video services provided by Vacaville's very own Choker Films. Video production, editing, and compositing services.